Well, good morning. On behalf of Judge Koropkin and Judge Bazzi, welcome to our final day of case call here in Grand Rapids. Looking at the docket, I see we have a whole lot of experienced appellate attorneys here, so I'll be very brief. You all know you're in allotted time. If you find yourself sharing time with a co-defendant, if you could please identify how you're going to be splitting your time, and then or co-party. And then if you have a client in the courtroom, I don't see any, if you could just please identify them that you have a client that's in the courtroom. So with that, why don't we start with item number 16, which is People of the State of Michigan versus Smith 370449. I believe we have one counsel on remote.
Sorry, I'm having a little issue with my video here, so
No problem.
I'm doing my best, Your Honors. It's
No problem. You have 29 more minutes.
I don't anticipate using all of them, but I guess we never know. Good morning, Your Honors. Christine Pajak on behalf of Mr. Smith. I want to thank you for letting me appear by Zoom. I've also been in the midst of a family emergency for 2026, so if I'm a little less focused than usual, my apologies. I'm going to largely rest on my briefs, but my client has asked me to let you know that he fired me and they did not let me withdraw. And that he wanted to emphasize that sort of the sequence of events was that he had a cluster headache and then overdosed before 911 was called. So while the trial court statement that he did not see Mr. Smith suffering from a cluster headache, at the same time, while that might be true, the prosecutor has not proved he was not suffering from a cluster headache. And the doctor testified to the fact that he was being treated for cluster headaches and also testified about the behavior of someone who had suffered a cluster headache and then overdosed. And with that, if you have no questions, I guess I would reserve my remaining 28 minutes for rebuttal.
Just a question.
Yeah.
You said that my client fired me, but I could not withdraw. Can you just
Yes. Elaborate?
Yes.
He fired me. I filed a motion to withdraw, and the trial court denied it. Mr. Smith represented himself throughout trial, and I think what the trial court was expressing was that Mr. Smith had perhaps had a few too many attorneys.
I understand, but so this was a motion that was filed with the trial court and the trial.
That's right. I filed a motion. Yes, I filed a motion with the trial court. I don't know. I think it was July, and that motion was denied. I think that should all be in your docket entries.
Got it. Thank you. All right. You've got plenty of time for rebuttal. Mr. Morton, go right ahead.
Good morning. May it please the court. Assistant Attorney General Brent Morton on behalf of Crawford County. With regard to the cluster headache, this was a bench trial, but the jury instruction indicates that intent can be determined from what an individual says, does, or anything else in the record. And well, in this case, there was video evidence of the defendant barricading himself in the bathroom, fighting with officers, headbutting the deputy, spitting blood at medical workers, and trying to grab the deputy's gun. this is not the flailings of someone who's in pain under a cluster headache. These are intentional acts. Now, in the brief, opposing counsel argued that his intent was to commit suicide by these acts, but it's not a specific intent crime. And so our position is that there was sufficient evidence to find him guilty. We also believe that he wanted to represent himself and that he was given a lot of opportunity to be represented by counsel if he wanted. So we believe that you should affirm the conviction and the sentence, and I'm happy to answer questions.
I don't see any. Thank you.
Thank you very much.
All right. Any rebuttal?
No, Your Honor, thank you.
All right. Thank you both. That matter is submitted. Turning now to item number 17, People of the State of Michigan versus McAllen, 368049.
Good morning.
Morning.
Mitch Foster for Richard McAllen. So a couple things right off the bat. I did file late yesterday a motion to remand. I was going to ask that as relief today when I argued, but I thought that maybe procedurally it would be better to actually file a formal motion. But the motion was very brief and it just attached the same two affidavits in support of the motion that were attached to my brief. So I don't know if the court had an opportunity to, or was even aware that that was filed yesterday around 3-4 o'clock.
The affidavit from the mother was also the same affidavit. That was also part of the
mother as well as the trial attorney.
right. And those are both part of the record previously. Okay.
A and B. Well, part of the record attached to the motion for a new trial that was denied, and the Ginther hearing was denied at the same time the motion for a new trial was denied.
Right. Okay.
So we have, well, first of all, I wanted to, as I was preparing, I was looking at my reply brief and the issue with regard to the other acts of domestic violence. I do agree with counsel that notice was provided, even though it wasn't formal notice, because the discovery did show Detective Kristen O'Toole did say that these other acts of domestic violence were reported by the complainant. So I would withdraw my second point on the reply brief. However, I do think that goes into ineffective assistance of counsel, the fact that counsel did not file a motion in limine to exclude other acts because she was aware of it from the discovery where Detective O'Toole was told about these other acts of domestic violence. So I think any way you look at it, it was error. And there should have been at least a 403 analysis on those other acts before they were admitted. But they just happened. There was testimony at trial and there they were. They're on the record and we're stuck with it. So I think that was another thing that we could develop at a record at the Ginther hearing. Why wasn't a motion in limine to exclude those filed? Also, as I was reviewing, I looked at the police reports, and it gets back to the main point is the dates that the offense was said to had happened. There was two officers that took the report. The first officer, I think, was somewhere on campus at Lake Superior State, was Officer Kazmarek, and the complainant, Miss Blum, told police that told Kazmarek first that it happened either on November 12th or the 14th.
Didn't she also say the 16th?
Sorry.
Wasn't it also the 16th
Not what is in the police reports.
from her testimony?
Well, yes and no. There's conflicting testimony. But I'm going to get to that later, Judge Bazzi, about what her testimony actually was. But she not only told Officer Kazmarek, but she also told Detective Kristen O'Toole, the detective officer in charge of the case, that it happened on either November 12th or November 14th, which was Monday or Wednesday. Now, it is true that during the prosecutor's trial direct exam of Piper Blum, she said it could have been on Monday, Wednesday, or Friday, but she wasn't clear, and she didn't. It was very vague how she testified on direct exam with the prosecutor as to whether it could have been that Friday. There was nothing in support of why it could have been on that Friday, and that conflicts with her preliminary exam testimony that was used for impeachment. The trial attorney did not actually read the record of the preliminary examination when questioning the complainant about what she said, but the direct exam at the preliminary examination on page 7 shows the prosecutor referenced between November 12th and November 14th did something happen, and then describe what happened on between those days, and then she goes in to talk about what happened. Nowhere in the preliminary exam was Friday the 16th ever mentioned, and that testimony was used by the trial attorney, kind of a sloppy impeachment, but it was called out to the jury that it was on the 12th or the 14th during cross-examination at trial.
Well, let me ask you something. Let's just say we assume that she did not testify to the 16th. It was just the 12th and the 14th. But on the 14th, ultimately the mom did testify that about the alibi, that he was home at the time. And couldn't the jury have just disregarded that testimony and chosen not to believe the mom? I believe the school records that were provided indicate that he was absent on that day. But the mom testified that he was home. So didn't essentially the jury hear the alibi testimony that you're indicating they would have been helpful? And can't we presume that by the jury hearing it and still finding him guilty, that there was a credibility issue and they determined that testimony not to be credible?
Judge Bazzi, I would agree with, is it Bazzi or Bazzi?
Bazzi.
I'm sorry. Oh, good. Judge Bazzi, I would agree with you if she was permitted to answer fully and completely. But I was looking at this just yesterday, and what she said was, it's not possible that he raped Piper Blum on the 12th or the 14th. And then there was an objection, and they went in. Prosecutor sought to have the judge hold the attorney in contempt, and they had this big back and forth, and then they went back to trial. So there's nothing more after that. There was nothing about the snowstorm. There was nothing about the, how the mom didn't see any footprints out in the snow where the dog is usually let out. There was nothing about any, the lack of, wet clothes or anything in the home. The mother was completely cut off, and the jury would have seen the objection, seen that there was no further development, and most likely disregarded it completely based on the objection that was apparently sustained. So I would strongly disagree with the fact that the jury heard it and considered it and said, despite that, we're still going to find guilt. So I think if you go and look at the record of what was said, just to refresh your memory about that testimony of the mother, I think you'll see that it was very limited and it didn't get into any of the details. And also it didn't get into the details of the trip to the hospital, the War Memorial Hospital, where he thought he had an STD or urinary tract infection. It turned out something else, but that was also happened, and he was feeling sick that day, didn't go to school. So that was also not part of the record that was testified to. So and actually the judge at the motion hearing brought up the same point that you did, Judge, about, plus the mom already testified. So, but I think that judge was wrong, and I think you were mistaken on the facts as well. But
And what about the Friday? Why, you said that the testimony differed between the preliminary exam and the trial?
right.
Okay.
At the
So what's the implication of that? Because I think at the trial, the complainant testified that it could have been on a Friday.
Yes, let me try to go through that a little bit. So the trial, if the jury has all the evidence about what the alibi was on the 12th and the 14th, they could have, reasonable jurors could have ruled those out completely. And then it would have been only on the Friday would be the only thing remaining if there was no ineffective counsel and the evidence was presented. So if we're only looking at the 16th, we have Piper Blum, who was very vague and said, well, I don't know, time that week. But then we have what the police officers were reported. So counsel could have brought both of those police officers in and questioned them about, well, didn't she report to you that it was the 12th to the 14th? And that wouldn't have been hearsay. That would have been not for the truth of the matter asserted. It would have been to impeach that witness. And we also have Haley Jackson, who testified that she never said anything about the 16th. So if the jury's comparing all the testimonies, I guess you have like a Venn diagram, I think, with is that what they call it, with the two circles?
Yeah.
Those only intersecting common dates are the 12th and the 14th. When you compare Haley Jackson, when you compare Piper Blum at the preliminary examination, and when you compare Piper Blum at the trial. And at the trial, she was very vague and didn't even offer Friday. It was more presented to her by the prosecutor. And then she said, it could have been yes or something. But it was very vague and it wasn't very strong. So I think the jury can see all of that and determine, well, Haley Jackson said this. Piper originally reported to the police these 2 days. And now for the first time at trial, we're saying, well, it could have been on Friday. So I think when they look at all of that, if they would have had those two alibi dates, the Monday and Wednesday, we don't have to prove that the result was different, only a reasonable probability. And I think that there was no trial strategy because you see the affidavit, although that's more of an offer of proof, it's not sworn testimony. So I think if the court really wants to make a truly informed decision based on all the facts and the circumstances of the failure of counsel to provide this alibi, we need to have a remand for a Ginter hearing. And I would ask that the remand, we'd be able to ask why there was limity to preclude the other act's evidence, because that goes hand in hand with ineffective counsel. The other thing I would like to add in terms of prejudice, I would like to say that the dates are really wishy-washy with Piper Blum, except when she told the police the 12th and the 14th. There's no doubt about that. But she also told police, and I believe she testified at trial, that she had consensual sex with Ricky after when she claimed she was raped, at least once. And in terms of prejudice, if someone's raped within the last 2 months, because I think it was about 2 months later, they remember the two dates, but then when you come to trial, you can't remember what day it was. Well, even if it was 2 months ago, you should have been able to remember a particular date. If something that serious did happen to you, how could you not remember who was there, what happened, when it was, the day of the week? All we have is like, well, she didn't go to class and it was either Monday, Wednesday, Friday. But of course, I mean, I would make the argument, and everyone's different. Every victim's different. I'm not saying she was a victim, but if she was a victim, I think most victims would remember at least the day of the week, especially something that recently, just 2 months later. And of course, in CSC cases, we don't have to pinpoint the exact date, but that's not what this is about. This is about the strength of the evidence and whether there's prejudice. So I acknowledge that they have to prove the date of the offense. And unless there's any other questions, I'll rest on my brief.
I think we're all set. Thank you.
Thank you.
Good morning again. May it please the court, Assistant Attorney General Brent Morton on behalf of Chippewa County. With regard to the motion for remand, I don't believe he's met his burden under Ginther to show that there's a need for a hearing. He's provided some affidavits that are really not very useful in my accounting. But he has not established that they would actually be alibi witnesses. And that's part of it is because of the days, and part of it is because mom admits I was at work. So the time that the rape occurred, she was not with her son, and that's an alibi. I was with this person. She was at work. And she says that in her affidavit. So they're not really alibi witnesses, and I don't see that a remand's appropriate. This is, with regard to all the claims of ineffectiveness, he has to prove harm. He has to prove that there'd be a reasonable change in outcome. But remember, this is a confession case, and not a confession to an officer, a confession to one of the defendant's best friends that he did this. So it's not a question of whether or not it happened. It's a question of, well, I guess it's not a question of whether or not it happened. His best friend, one of his best friends has stepped forward and said, right afterwards, I picked him up from the dorm and he told me about this and then he apologized. So this is not an issue of whether or not the crime occurred. And finally, with regard to the dates, the victim, PB, did testify and transcript on the first day, pages 146 and 147, that this occurred on the day she had history class. And she knew that because her roommate would get up early and go and I think ice skate or something. And that's why the door was left unlocked. And it was also the day that she missed history class because she was so distraught from what had happened, she couldn't go to class. Her history class occurred on the 12th, 14th, and 16th of that week. She knew the week. But remember, these are sexual assault crimes. And I have to bristle a little bit at opposing counsel. And I know he's doing his job. I respect him. We get along away from here. But the reality is there's a lot of victim blaming going on. She should know the day. She was sexually assaulted. That's why the jury instruction was given on the second day.
Mr. Moore, we're right here.
I'm very sorry. You're absolutely right. I apologize. On the second day of the transcript on pages 77, 78, the jury was instructed time is not an element of the crime. And in these sexual assault cases, that's why. She couldn't remember the day. So these are the days that were given. They don't fit into what Mr. McCallum has characterized as his alibi. So they want to magically make that 16th, the day of the 16th, disappear. But it doesn't. In fact, the jury was instructed that these are the 3 days that it may have occurred. I apologize for getting frustrated. I appreciate the court's patience and I'd be happy to answer any questions.
I think we're all set. Thank you
very much.
You bet. Forster?
Just one thing. Of course, we know the date isn't required, but the purpose of that is generally for children and for events that happened years ago, maybe decades ago, where you might not be able to pinpoint where you were, 25 years ago on a Tuesday, as opposed to sometime over the summer or sometime that year. You don't even have to say the year, but when something happened in the last, or allegedly happened in the last 2 months, most people, in my opinion, should be able to at least come up with the date and the circumstances surrounding the date, even though it's not legally required.
I mean,
But I think
I take it the reason this is significant is because had that been used in impeachment to challenge credibility, that would have been something that could have been done to challenge credibility. But then the issue for us is, well, okay, yes, but if you stack that up against all of the other evidence, is it enough to undermine the confidence in the verdict, right?
I agree, Judge Kropkin. And I think that's why it's so important that she did acknowledge that she had sex after this alleged rape. Why would someone have sex with someone that just raped them a week or so?
And
So I think the jury I think that's a very important fact that this court can consider when determining whether there was prejudice.
But another important fact is that there's evidence that he confessed to a friend of his or someone he knew, and then there was the roommate. There's a sort of an outcry testimony to the roommate as well.
I understand that.
So we have to weigh all of those
Yes,
things in
yeah.
addition to the sort of question about whether it was on a Friday or not.
I agree, Judge, but I think confession is a very strong word for that conversation. I didn't see that as a confession. I saw that as acknowledging something happened during a relationship, and whether it was consensual or non-consensual is very subjective in what was said and how that was interpreted by the friend. So I would strongly disagree that that was anything near a confession. It was maybe an admission of an act taking place with the circumstances are vague, especially someone with an ongoing consensual relationship that continued after that act that was allegedly a confession. So I think the court can look at all of that, and I think there is prejudice here because it's just a reasonable probability. And I think we've met that, but I think I get their hearing would flesh out those details. Or thinks it needs to have a more full record to decide this case.
Okay. I think we're all set. Thank you. All right, that matter is submitted. Turning now to item number 18, People of the State of Michigan versus Phillips, 372090. I believe both counsel are arguing remotely.
I was joining as panelist. Judge, I don't know if you said anything to me. I'll start my video in a moment.
All right.
Thank you.
Yeah, Ms. Murphy, you're up. So why don't you start your video and you can proceed when you're ready.
Yes, Judge. Good morning, Your Honors. May it please the court, Kathy Murphy, on behalf of Jeremy Phillips. This case turns on two issues, either of which requires reversal. First, the plea was not understanding and voluntary. Mr. Phillips did not simply express dissatisfaction with his sentence before sentencing. He told the court he did not understand what he was actually pleading to. He did not understand his sentencing exposure. He had not meaningfully consulted with counsel, and he would have gone to trial had he understood the consequences. These are contemporaneous assertions of misunderstanding, not simply hindsight regret. Under Guyton, a plea is invalid if it's induced by a misunderstanding of sentencing consequences. Due process requires actual understanding, not formal compliance. Here, the trial court repeatedly stated sentencing considerations were superfluous and had nothing to do with the plea. This is incorrect. A defendant must understand the real penal consequences of a plea. The court further relied on its personal familiarity with Mr. Phillips to conclude that he must have understood. That can't substitute for constitutional analysis. Plea validity turns on the defendant's understanding, not the judge's confidence that he knows what the defendant understands. Next, the wrong legal standard was applied. Mr. Phillips moved to withdraw his plea before sentencing. Before sentencing, plea withdrawal should be allowed in the interest of justice, absent substantial prejudice to the prosecutor. The trial court rejected that standard, stating that the only permissible basis for withdrawal was an error in the plea proceeding, which was the post-sentence test. That is a legal error, not a discretionary call. And the prosecutor was never required to show prejudice, as the rule requires. Under Spencer, credible claims of misunderstanding or innocence raised before sentencing satisfy the interest of justice standard. Mr. Phillips met that burden. Mr. Phillips is asking that his plea be withdrawn. And we ask the court to reverse and remand.
Thank you. I don't see any questions. Go right ahead.
Good morning, Your Honors. For the record, Mike Rolla from the Otsego County Prosecutor's Office on behalf of the plaintiff appellee. As a starting point, I'd like to thank the court for allowing me to appear by Zoom. We're currently up here in Gaylord under freezing rain, and I would have been driving through that for about 5 hours to get to the court. I will be basically relying on my brief. However, I would like, with the court's permission, to address a few brief points. I don't want to waste the court's time any further. As to the claim that the defendant did not understand the plea, as the court's well aware from the copious transcripts, copies of which were attached and referenced in our brief, not only did this court go over repeatedly the reasons for the plea, the basis for the plea, but even before trying to even accept any factual basis, not only went over all conditions and concerns the defendant expressed that he had, but got acknowledgments from the defendant that he now understood and all his questions were answered. It is only until some 6 weeks post-plea that the defendant then even makes any references to suddenly not understanding. As set forth in our brief, this is simply once he's had the opportunity to talk to his attorney, once he's had, more importantly, perhaps, the opportunity to review the sentence recommendation, this is now he is dissatisfied with the sentence. As to the claim that the wrong standard is applied, I would respectfully submit to the court that even under a standard of fair and just interest of justice, the defendant has not met that burden. At no point in time, I'm sure the court noted, that has the defendant ever claimed he was actually innocent, nor that he had any facts to present a valid defense. And as this court is also well aware, comments made after that might be contradictory to the claim of statements made in his plea. In most cases, those can't even be considered by the court. Unless the court has some additional questions, which I'll be happy to answer, I would then release the rest of my time. Thank you, Your Honors.
I don't see any questions. Thank you, Ms. Murphy.
Your Honors, I would also like to thank you for allowing us to appear via Zoom, and I would like to apologize for being late.
No problem at all. Anything further?
No, judges, thank you.
Should we both know it's a clear sunny day here in Grand Rapids.
Much appreciated, Judge.
65 degrees. We miss you. All right, the matter is submitted. Turning now to item number 19. People of the State of Michigan versus Woodby. Or Woodby, 369059. I think we're waiting for one party, the appellant, who is arguing remotely.
Your Honors, the attorney was just in the gallery and I am calling her because I believe she got disconnected. Just one moment.
All right, well, while we wait, has the appellee on number 20 checked in?
Your Honors, she is here now. If you'd like me to go ahead and promote her for number 19.
Yes, please.
Thank you.
All right, we can see you.
There we go. Good morning, Your Honors.
Morning.
I apologize for my technical difficulties. I'm sorry, I'm offsite in another court here. Melissa Crosskopf on behalf of Mr. Woodby, who is the appellant in this matter. I don't have anything to add to the briefing that I've submitted to the court, but I am happy to take any questions if the court has any for me.
Nope, I don't see any.
Thank you.
All right, well then that matter is, I'm sorry, I didn't see you there. I'm sorry, go right ahead.
Good morning, Your Honors. Monica Wilson, Assistant Attorney General. I am standing in today for Attorney Kayla Carino, who filed the briefs in this matter. I would simply rely upon the briefs that were filed unless Your Honors have any questions for me.
I don't see any. Thank you.
Thank you.
Thank you for being here. All right, I imagine you don't have any rebuttal?
No, Your Honor. Thank you.
All right, very good. Thank you both. That matter is submitted. Turning now to item number 20, that's People of the State of Michigan versus Schneiding, SCHIEDING 371318. I understand the appellant has waived.
Good morning, Your Honors. Again, Monica Wilson, Assistant Attorney General on behalf of the people. I did receive notice over the weekend that Attorney Helton had waived. So I would simply rely upon the briefs and just answer any questions that Your Honors may have.
All right. I don't see any. Thank you very much.
Thank you, judges.
That matter is submitted. Turning now to item number 21, People of the State of Michigan versus Buford 369971.
Good morning, Your Honors. Gabrielle Barber from the State Appellate Defender Office here on behalf of Mr. Lawan Buford. I don't know if I need to wait or anything for appellee. I didn't know if you waived or not. I haven't seen anything.
Oh, okay. All right. All right. It's a ringing endorsement. Go right ahead.
All right. Thank you, Your Honors. The trial court's decision here to enter a jury verdict, finding Mr. Buford guilty of maintaining a drug house for illegally keeping 15 ounces of marijuana in his home, highlights how this improper interpretation of MRTMA applying to the public health code can lead to prosecuting loopholes from the express purpose of the MRTMA. In simpler terms, Mr. Buford here is convicted of a felony where, after the people of the state of Michigan voted to pass the MRTMA, a felony no longer exists. And Justice Bolden highlights this problem in her dissent from the Supreme Court's order denying leave in People versus Soto. And I just want to quote very briefly from it. In talking about the problems between the MRTMA and also Article 7 of the Public Health Code, Justice Bolden says, quote, "This disjunction is not trivial. It creates a dual scheme in which nonviolent marijuana conduct explicitly protected by the MRTMA can lead to life-altering criminal penalties if the conduct is characterized as an offense under the PHC, or the Public Health Code." I just want to make a couple of points about this. Since Soto has come out, since the brief was filed, I know this court also came out with a recent unpublished opinion in People versus Edwards. And so I just want to follow up on a couple of points. We have People versus Kedgebu and we have People versus Soto. Kedgebu here is the controlling case, not Soto. We're not dealing with the intent to distribute here. The jury acquitted Mr. Buford of possession with intent to distribute. And when considering the question of whether he was guilty of maintaining a drug house, the jury asked two questions, implying that it was considering the theory only that he was illegally keeping. They first asked whether they needed to decide that he had both intent to distribute and illegally kept the marijuana in his home, or if it was either or. The judge instructed it was an either or question. The second question that the jury asked was how much marijuana Mr. Buford could legally keep in his home. These two questions that the jury asked tell us that they really didn't, in addition to acquitting him of possession with intent, they did not think that he had the intent to distribute. So this puts us in a different world than People versus Soto. And the people in the case People versus Kedgbu here tells us that when circumstances have been considered by both MRTMA and Article 7, such as the possession of marijuana in the home, that the MRTMA is what dictates what happens with this person. So Soto also differs because it relied on whether or not this activity was proscribed by the Public Health Code and is already considered by the MRTMA. And as I've said, possession with intent to deliver or any intent to deliver is not considered or prohibited under the MRTMA. Possession, mere possession, and how much a person can possess, how they can possess it, inside or outside of the home, is exactly what the MRTMA considers.
So I think I agree that potentially MRTMA would supersede and control over anything that's in the Public Health Code. I think that's pretty clear. But which part of MRTMA, textually speaking, is it that you think does that for your client here? Because if you piece together, if you go to the part that says it's, if it's not more than 2 times the amount that's allowed, then it's a civil, I think it's a civil infraction. But at the beginning of that subsection, as I'm sure you know, it says, except for a person who engages in the conduct described in Section 4. And then if you go back to Section 4, it allows you to possess a certain amount of marijuana in your home. But it says that if you're above 2.5 ounces, which the defendant was here, it has to be stored in a container or area with locks and that kind of thing. I think the record's pretty clear that it was not in a locked container and it was more than 2.5 ounces. So that seems to suggest that, although maybe maybe it wasn't wise to write it this way, that the text of the statute doesn't actually supersede the Public Health Code in this particular instance.
I agree that the reading of the MRTMA is quite complicated and maybe somewhat doesn't make sense when we're going back and forth through these various sections. It is also true that in Section 4, which is the issue, this lockbox limitation essentially of possessing marijuana in the home, may seem like it basically excludes Mr. Buford's coverage under the MRTMA and protection under the MRTMA. However, why I started by talking about People versus Kedgbu being so instructive and important to analyzing this issue is because in People versus Kedgbu, this court instructed how important it is to read the entirety of the statute. And I understand textually, statutory interpretation, we have to rely on the text. But what's really helpful for us is that the legislature put the purpose and intent in the text of this statute, which is there are kind of twofold purposes of this statute. The first is to prevent the arrest and prosecution of a person for the possession, legal possession of marijuana or possession of marijuana when they're 21 years or older. And also, kind of dealing with the commercial distribution and production of marijuana, which, as we said, isn't at issue here, right? So if we read the entirety of the statute, including Section 2, this purpose and intent part of the text, it does not make any sense to prohibit a person's coverage and protection under the MRTMA for possessing marijuana simply because it is not in a locked container. there's another point that I want to make about the text of the statute. So when we're looking at section 5, permissive acts for individuals, which is the section instructing 2.5 ounces on a person, 10 ounces within the home, anything more than 2.5 within the home has to be in the locked box. That's section 4. When we're looking at reading all of these sections together, the part that excludes Mr. Buford for not having the over 2.5 ounces within the home is for section 4. It's 1H or 1I or something. I'm of course blanking, but this section, before this particular section that prescribes this behavior, there is a list of all of these other types of things that are not protected under the MRTMA, namely possession while driving, under the influence, and things that have already been criminalized, right? Otherwise, possessing marijuana within a locked box is not otherwise. I'll start over, sorry. Not possessing your marijuana within a locked box within a home is not otherwise dealt with in a criminal statute, as far as I know. The MRTMA is what is telling us that this behavior can otherwise maybe be prosecuted somehow. However, as I said, if this court is reading the entirety of the statute, I don't believe that that's the case. But again, I go back to People versus Kedgbu, and why it's different from People versus Soto is that the behavior, the activity that Mr. Buford is involved in, which is possessing too much marijuana in his home, not in a locked container, is not otherwise prohibited in our public health code if we're applying MRTMA.
Isn't it an element of maintaining a drug house?
So this is another.
It can be an element of
potentially, but this is another problem that we have is this, and it connects to the instructional issue that we also raised. What is illegally keeping under maintaining a drug house in the context of the MRTMA? And what the judge instructed the jury on was incorrect. It's not entirely accurate because, first of all, I mean, if we're talking about the locked box container, then it isn't 10 ounces, right? That is what's permissible within the home. But it doesn't fully encompass what is prevented and what is not prevented by the MRTMA, regardless of how you interpret it. And so that's another problem that we have in this case, is that maybe it is an element, illegally keeping. Maybe illegally keeping does include the way that you possess or store your marijuana within the home, considering MRTMA. I don't know that that makes any sense, considering, again, the purpose and intent of the MRTMA as stated within the text. But that is another problem that we have, is what is illegally keeping under the MRTMA under maintaining a drug house within the context of the MRTMA. Because of all the reasons that I've already explained of how we should be interpreting this statute and the purpose and intent and the text of the statute, illegally keeping under maintaining a drug house cannot include the possession of marijuana, even if it's these technicalities of possessing within the permissible range of being only getting a civil infraction for this activity, but maybe not in a locked box.
Because you only have 15 minutes, you only have a few more minutes left.
Thank you. I guess I don't have to save anything for rebuttal, so I just want to make sure that I touch on all of my points. But again, if this court has any questions, any additional questions, I'm more than happy to answer them. I believe that's everything that I wanted to make sure that I said. Thank you so much, Your Honors.
All right. Thank you. Thank you very much. That matter is submitted, number 21. Moving now to item number 22. Mary Freebed Rehabilitation Hospital versus Esurance Property and Casualty. 370846. We could just clarify who's representing who here. All right. All right. Got it. Okay. Thank you very much. Go right ahead.
Thank you.
So may it please the court, this is a medical provider no fault claim. My client, Mary Freebed, filed action against two insurers, USAA and Esurance. The underlying facts of the accident are my client treated a motorcycle operator who was catastrophically injured in a crash with a car on November 12, 2020. The striking vehicle had coverage under an Esurance policy.
For $250,000.
That's correct. And the injured person's household coverage was unlimited PIP medical through USAA.
You'd agree it's undisputed that the coverage issue is not an issue in this case. Priority and stacking is the issue in this case, not whether, maybe this is a better question for USA later, but it seems to me that whether the particular policies apply is the wrong word. But I think you know what I'm getting at in terms of, the question is really an issue of whether they can be stacked.
I would say that is a question as it relates to the claim against USAA.
Right.
The claim as it relates to Esurance is whether its 250 medical limit, $250,000
Was exhausted or
whether it applies.
Right.
So USAA defended the claim my client brought on the grounds that because they were second in line in priority, that they could never have liability. Esurance defended the claim on the grounds that all they would ever have to pay in PIP medical is $250,000. And because they established in the case that they did that, they're out. The court agreed with the defendants on both of their arguments. We submit both positions were incorrect, which is why we asked for remand. So, but I'd like to speak to the issue of USAA's position, which is, as the court indicated, the stacking argument. Our law has been clear in no fault for a long time. Coverage and priority are distinct concepts. And our law has always held that more than one no fault policy can be applicable at the same time to one loss. Now, I would submit to the court that one of the reasons that we don't have a lot of jurisprudence in Michigan that addresses it is because before the reforms of 2019, the benefits available under all policies were redundant. So law mandated that they offer the same kind of benefits, but now we have limited or opt-out or cap policies and it becomes an issue. So our statute has given guidance that priority and coverage are distinct. So first I'd like to speak to 3114.5, which is the priority statute. That statute simply indicates the order in which a claimant shall present their claim. It does not say that when you present it, carriers down the chain are absolved of liability. It is a shall claim from insurers, plural, in the following order. Another statute in the No Fault Act, 3107C6, adds to this and signals how more than one policy can apply at a given time. That statute says, if benefits are payable under two or more insurance policies, the benefits are only payable up to an aggregate coverage limit that equals the highest available limit under any one of the policies. Of course, the logical underpinning of that statute is more than one policy can apply simultaneously. Now, the defendant on that point suggests that that's really only designed for situations where in the same level of priority, not sequential orders, the limits are different, but that's not what the plain text of the statute says.
Well, it does say in the same order of priority, subsection 7.
3107C6 does not say that, Your Honor. I respectfully disagree.
Oh, I'm sorry. I'm on 3114.7. So you're looking at the other one.
3107C6.
Yep. Okay. I apologize.
But
Thank you.
I'll certainly address that statute later if the court will allow. In addition to those statutory signals, I would submit, Your Honor, that our jurisprudence has held for a long time that pay and chase is the law of the land in no fault. And of course, the pay and chase theory is that if a lower in chain carrier, lower in priority carrier should and must pay benefits and not delay the payment of those benefits because there is concern about maybe the existence of higher priority coverage. That's always been the law in our state. I'll start with a case from 1987, Huber versus Frankenmuth, and then also touch on Griffin versus Trumbull. So pay and chase theory that a lower in priority carrier would owe benefits is grounded in the notion that more than one policy can apply at the same time to the same loss. So Griffin versus Trumbull, in my mind, is the most instructive case because it's the most recent from our high court. And in that matter, the plaintiff in the case was a motorcyclist. He had a personal policy through Trumbull. Despite his best efforts during the 1 year period in which it should happen, he was unable to identify what was admittedly a higher priority insurer. In that case, it was Harleysville Insurance Company. In the trial court, the court ultimately said, well, you didn't identify them and therefore you can't reach your own coverage. Our high court said not so. In that situation, his personal policy must respond to PIP, admitting though at the same time that Harleysville, the carrier that was higher in the order of priority, wasn't identified and wasn't part of the case. The logical underpinning, the legal underpinning is that claim is viable. Priority can't be a defense to an otherwise payable claim. Huber versus Frankenmuth is much older. It's 1987. That case was a situation where the highest priority carrier, motorist, name now escapes me, motorist Branch Motor, was highest in priority, and the plaintiff in that case sued two carriers, Branch Motor and Frankenmuth. And during the course of the litigation, once priority was established, the court let out the second in line carrier, Frankenmuth. Shortly thereafter, it became clear that Branch Motor had to declare bankruptcy because of insolvency issues. At that point, the plaintiff sought to reintroduce Frankenmuth into the case because there was concern about the viability and the damages available under the highest priority carrier. And the court said, absolutely, the second in line carrier could and must come back into the case to pick up the damages to the extent that the bankrupt carrier or the bankruptcy proceeding wouldn't have enough assets to pay the claim in total. Again, the legal underpinning of that analysis, the logic, is that simply because there is a higher priority carrier doesn't absolve the lower in chain carriers from an obligation to pay. Lastly, as it relates to the USA policy in particular, our jurisprudence has always held that to the extent that a policy provides coverage that the statute may not mandate, that coverage can be enforced. And in this situation, it's undisputed. Mr. Slade is a covered person under the USAA policy, and the existence of higher priority coverage is not an exclusion to that coverage. So that is the affirmative argument. Now, I'd like to speak a little bit in response to USAA's position. USAA responds to these arguments and did in the trial court by saying, under 3114.6, that's the only circumstance where our statute talks about laddering down the order when the first in line carrier either doesn't have enough. And I would respectfully disagree with that point. And the reason is 3114.6 is designed to deal with situations where the carrier identified highest in the order is either a Medicare opt-out policy or a QHC exclusion policy in such a way that the exclusion would apply to the claimant. Neither of those circumstances are present in this case. Secondly, simply because that statute talks about laddering down, it needed to say that because under the 2019 amendments, those opt-out and QHC exclusion policies were new. And so our law had to give guidance about what is the motorcycle claimant to do in circumstances where that kind of policy stands first. Again, factually, not the situation we have here. I would submit to the court that as it relates to USAA, it has always been the case that they would bear liability. So how it plays out in this case is as follows. To the extent that the striking vehicle highest priority carrier is allowed to enforce its limit, they would get the benefit of that limit. The USAA would get the benefit of what was paid under that primary policy, but the remaining damages, which in this case are significant, Mary Freebed's charges for this individual were over $1 million during the course of his stay. Those benefits can be reachable as against USAA under this analysis. Unless the court has questions on that stacking argument, I'll now move to the esurance, which is an alternative argument.
I have one question, and I know the priority is unique here, unique in terms of the typical case that we see between two vehicles, right?
Correct.
What I'm interested in is the next case down the road. If you're correct on the stacking issue, if the vehicles involved here weren't a motorcycle and a motor vehicle, but instead were two motor vehicles, would the answer be the same?
It would, but I would submit to the court that given the reforms, recall, I'm sure the court knows because the court's been on the bench a long time. In the pre-reform world, vehicle occupants had a deeper order of priority, much like the motorcycle priority does exist today. When the legislature changed it in 2019, they narrowed it. So in the typical car versus car case, generally speaking, there's only going to be two steps to the priority analysis. Do you have your own coverage? If not, do you have a spouse or relative within your domicile that has coverage? After that, vehicle occupants go to the MACP. So I would submit that the answer would be the same, but the likelihood of stacking in those situations is much, much more narrow than it would have been if the priority statute for vehicle occupants in car versus car situations was as it existed before 2019.
So as long as the injured party within the vehicle has their own insurance or is a resident relative of a different policy, that would be their priority. And if not there, then they go to the assigned claims.
That's correct.
Is there now a limit on assigned claims?
There is. It's either 250,000 in PIP medical or in very unique circumstances, 2 million.
Unique circumstances are kind of irrelevant to this.
They're relevant to this circumstance, though that would apply in a situation where during a 30-day period in which a person loses their qualified health coverage, an accident occurs and there's not otherwise applicable coverage.
But let me rephrase it this way. Suppose in this particular situation, everyone had a 250K cap. No one had chosen the unlimited option. And expenses exceed 250K. Can Mary Freebed go to the assigned claims plan? No, right? Okay.
Because in this situation, there's no seeking here of duplicative benefits. The reason this situation needs to be resolved in our judgment, and the way we've offered the trial court and this court, is that there are uncovered damages that this plaintiff should be able to access because those limits are distinct.
I guess, right. But in a situation where everyone has a cap at 250K, there are going to be services that are not going to be compensated for. And, there are these four priority levels under subsection 5. Once you get down to the end of D, you're saying you're done. You can't go to assigned claims or anyone else to get, except maybe in the $2 million unique situation.
The limits would need to be different for that laddering to occur in our judgment. It functions more like, I would say, a coordination in that way, because the second in line carrier who shares the same limit level as the first in line would not be exposed to the extent their level applies to something beyond that.
And then in the case where you had going up to subsection 1, in the case where you have a spouse or a resident relative at home, if they have the unlimited plan,
yes,
but the injured party has the 250K, you look to that last sentence of subsection 1, which basically says you just go to your own. You can't then go to your spouse's insurer. Right?
I would argue to the extent that there are different limits there and the coverage applies, you may be able to reach that. Now, if you have a a personal policy with a resident relative policy behind it, but the limits are different, you could reach beyond to the extent your damages would exist in that regard. What I would submit to the court is that this is a new issue, but it's new because our jurisprudence didn't really need to confront it in the past. And now it does, because these reform create situations just like this, where you have different coverage. And what's unique about the motorcycle situation is that that priority order still is fairly elaborate. There could be 4 or 5 different carriers that might have a liability based on the way that statute reads. Now, as a matter of policy, Mr. Slade and Mary Freebed are in a situation where, you know, Mr. Slade's policy, his household policy, he's essentially being, if you believe USAA, prevented from accessing it because of the operation of law. So he's forced to look to Esurance. USAA would say, we never have liability here. So he's stuck with a benefit his family didn't pick. One that in this particular case is far, far less than the damages he sustained.
Before, I know you're about ready to turn to the Esurance argument, but before you do that, if we agree with you on the stacking issue, then your client would receive unlimited PIP benefits from that policy, and whether it comes from Esurance, as you're about to argue, or whether it comes from USA is immaterial, really, for purposes of, for your client.
That is correct. So what I would say, Your Honor, is my client isn't going to get, so either Esurance's cap doesn't apply and my client gets unlimited benefits from Esurance because the statute says that's the default rule, at which point the claim against USAA no longer has viability because the damages have been resolved. Or if the Esurance cap does apply, then USAA has liability for what is left after Esurance's cap has been exhausted.
Or the trial court got it right. There's a third option that you.
Yeah, I disagree with that statement that they did,
that,
but yes.
But I wouldn't count your chickens.
Sure, I
quite
understand.
yet.
I
All right,
understand.
go right ahead.
As it relates to Esurance, the theory is distinct. So Esurance takes the position, we sold a 250 PIP medical cap policy to Haley Tanner. We acknowledge that we have to pay first in line for motorcyclists like this under this fact pattern, and they say we did so. Here's the proof. We need to be out. There's 2 problems with the argument. First of all, in order to have a 250 medical limit, like they say they possess, the insured, in this case Haley Tanner, the driver of the car and owner of it, would have had to have made an effective selection under the law of the 250 PIP medical cap. Now, the law micromanages how she would go about that. She has to sign a particular form approved by DIFs, and she has to sign it in a particular way. And there's 3 ways the statute says that would have had to occur. First is a written signature on a paper form. The second is giving verbal instructions under a recording that someone else signed it for her. And the third would be an electronic signature commensurate and compliant with the Uniform Electronic Transactions Act. Esurance in this case failed to prove there was an effective election. And why that's important is that our statute says when an ineffective election happens, under certain circumstances, the policy can default to unlimited benefits. So the reason they failed is there's no evidence she signed a paper form. That's undisputed. There's no evidence, and they've never advanced that she gave verbal instructions to someone to sign for her and that it was recorded. They've never attempted that argument. What they suggest is that under the UETA, the typewritten name on the form is compliant. Now, I would submit to the court that they have failed to satisfy their burden. And that's not a new argument. It's an argument that was raised in a very recent published case by this court, Bronson versus Esurance 348, Mishap 428. Now, I happen to have represented Bronson in that case, and Esurance was the defendant in that case. And the argument raised by Esurance in that matter was nearly identical. It was a typewritten form with the insured's name on it, and they indicated that was a compliant form under the law. The court in that case said the fact that Russell's name appears, Russell was the name of the insured in that matter, on the document does not by itself establish that the electronic signature was the act of Russell. In this case, in defending on the basis there was an effective election, they did the exact same thing, and they did it under the framework of having published authority that told them how they might go about that. Now, the secondary step, once there's an ineffective election, the statute says the policy will then, if a premium was paid, there is a rebuttable presumption the premium paid accurately reflects the level of coverage applicable. So that's their fallback argument. They say, if we assume for a moment the election was ineffective, we still win because there's a presumption that free bed didn't rebut that the 250 pip medical is commensurate with what applies here. Here again, Esurance failed in the litigation for a number of reasons. First of all, in the Bronson versus Esurance case I talked about a moment ago, our court has said to get the benefit of that presumption, it is not self-executing. You have to offer the court evidence that the premium charged accurately reflects the level of coverage offered. The deck sheets attached to the Court of Appeals briefs and in the trial court show Ms. Tanner had a $250,000 PIP medical on her deck sheet. She paid $21 for that premium, or $21 premium for that coverage. There is no evidence in the record connecting those two things together.
Why isn't, it says something like C supplemental certificate and then there's another document that says you're paying for the 250K.
Specifically the deck page.
Yes, the deck page says it's 250,000 PIP medical, and there was a $21 premium paid. Esurance's position is that is all we have to do.
Well, there's also an affidavit that amount was paid.
Well, what I would submit, Your Honor, is that there's a procedural and evidentiary problem with what they did there. So in this particular case, there was no affidavit. What they did at summary, despite being under an order to compel from a year earlier to give all the evidence that they possessed to establish that the amount paid accurately reflected the level of coverage. At the point of the summary disposition hearing, they said, Your Honor, to the trial judge, let us provide you with evidence of a payment ledger that this was a paid for policy.
I know I'm interrupting you, but it seems as though your entire argument relies upon one word, and that is accurately reflected. Would you agree with me that when you look at the deck page, clearly says $250,000, and there is a premium associated with that coverage?
Yes.
That was paid for and renewed, I think, on several occasions.
Yes.
So in my mind, that clearly reflects, in your mind, maybe not accurately reflects, but it clearly reflects a connection between those two. I think the point you're making is that although it, and now I'm putting words in your mouth, may reflect, they have to do more than that. They have to establish that it accurately reflects. And what accurately reflects, in your mind, you're saying you have to jump through additional hoops, and Esurance is saying, no, we don't. Right? Wouldn't you say if you boil it all down, it's coming down to what accurately reflects means?
You're framing the issue, I'd say, accurately in terms of what they would suggest. Here's what I would say. This argument I'm making here today and in the briefs is not new. All right. This issue was considered in Bronson versus Esurance, and I would argue decided. And what that panel said was that simply the existence of a paid for policy and proof that it was paid is not enough. An additional showing is needed. Now, in that case, the carrier Esurance did offer an affidavit from an underwriter who would be a person who could testify that when we charge that amount of money in that case to give 250 in PIP medical, those things correspond. Notwithstanding that published case existed, no such showing was made by Esurance in this case. They simply said, here's the ledger that shows Haley Tanner paid her premium. Well, that doesn't get them there because Bronson versus Esurance says it's not self-executing. More is needed. And what surprised me a bit about Esurance's position in this case is that they had the benefit of published authority about how to do it.
And so the declaration isn't enough.
It's not, that would be a self-executing situation in my mind. I believe more is needed to connect it. An explanation about why a premium paid, because premiums differ and they vary. And they would be the one to know because they're the one that wrote it. So they have to testify. An underwriter would likely be a person who could certainly speak with Foundation about why that number reflects the coverage paid to make those proofs. In this case, they did not do that.
What kind of thing would they say that's not already reflected in the declaration?
Well, I'm not sure exactly what they would say. That would be a burden they would bear. I mean, in the Bronson versus Esurance case, they offered an underwriter affidavit that spoke to the issue that premium corresponded with that under their program of whatever it was, if I recall correctly. You know, the law doesn't micromanage how they might go about making that showing. What the law now says is they must do it. Now, in this case, even the evidence they offered was evidence that wasn't provided in discovery. They were under court order by stipulation to answer our discovery requests, our request for production of documents, which they did not do. The court allowed them in a supplemental briefing after oral argument on the motion for summary disposition to provide that payment ledger. And we, of course, filed a supplemental objection to it, and that's how the record happened.
I guess what I'm struggling on that argument is that it comes down to apply the rebuttable presumption. It seems to me that that the insurance company would have to establish that there was a renewal or the like, that they received a $250,000 PIP policy, and that's what you got, and that's what you paid for. And that just seems to be crystal clear, to me at least, on the declaration page. I know you say that you have to do more than that, and I'm just gonna have to take another look at that Esurance case, but I'm just not. It seems to me that the issue is, did you get what you paid for? And if there's any doubt that you signed the form, that doubt is removed after you get a renewal. And when that renewal has PIP and it has $250,000 limitation of coverage again and again on renewals, and it has a premium associated with that. It seems to me that that removes any doubt that I would have in terms of whether the person got what they paid for.
With respect to the court, I would submit that because the issue has been addressed by a prior panel and because it is published, I do believe that would be binding on this court.
Yeah, I need to take a closer look at that.
That court's analysis of the resolution of that issue, which I would submit is exactly as I'm offering it, controls what this panel does with that issue. So to sum up, we're asking for a remand so we can continue this litigation to its conclusion. Because both defenses raised and rulings made by the trial court as to the Esurance cap and to the ability of my client to reach USAA were incorrect as a matter of law, and this matter should be remanded. I'll save a little time for rebuttal, I think, if I have some left. Thank you.
Yep, very good. Thank you.
Good morning, judges. Caitlin Kramer again on behalf of Esurance in this case.
You decide how you're going to split up your time?
I think I'll be very quick based on
Okay.
the comments you just made, Judge Cameron. I think I will maybe be max 5 minutes. Aaron and I did speak briefly, but Judge Cameron, you've nailed it. This policy was renewed multiple times. The declarations page states extensively. It makes that link. I think you and I might be on the same page on this, so I don't need to go into.
What do I need to focus in on when I
Absolutely.
take a look at that case again?
I'm glad you asked. Bronson does not say that the only piece of evidence we need to submit for the presumption is this affidavit. It asks for that affidavit because that was the only evidence that Esurance brought in that case. In this case, we have a vast amount of different evidence and more evidence. We have her own testimony indicating I wanted the bare minimum of coverage. I was looking for the bare minimum of coverage. That shows that she intended to opt out. We also have other cases that this court has determined on this opt-out issue that says the opt-out should reflect what the intent of the parties are if we can establish that. If you have the actual insured testifying, I wanted to obtain the bare minimum, which it is my understanding was not evidence that was presented in the Bronson v. Esurance case, so we are distinguishable in that fact. That should be good evidence to show you, along with the renewal, that she's never challenged that selection. She's never made any sort of debate on that selection. Plaintiff in their briefing tried to say, well, she doesn't remember, she doesn't identify the form. To me, that goes to the first part of the analysis on an effective opt-out under the statute. But my focus is primarily on the presumption because I do think we win there. I think the trial court did get it right to say, yeah, maybe there are questions on the effectiveness in the first place, but the presumption still should apply because we've met those requirements. Bronson reiterated that the requirements are simply, one, a policy is issued, the insured did not make an effective selection, but three, the insured made a premium payment. In Bronson, they said that discovery was needed on that issue of that affidavit because that person was not on a witness list, and they asked for more discovery on that point. That's not relevant here. Bronson, I think, can be read in concurrence with this case and come to the same conclusion that the presumption can be applied because the totality of the evidence shows she wanted the bare minimum coverage. Insurance paid that coverage to plaintiff, and there's nothing further that needs to be paid. And that's about it. Thank you.
Okay.
If any questions, I apologize.
Very, very quickly. I know this isn't your issue, but
Sure.
I'm curious in what your
Yeah,
thought. I'm going
absolutely.
to ask the same question in a moment as well. What are your thoughts in terms of the stacking issue if these would have been two motor vehicles?
I'm glad you asked. Sister Counsel and I were whispering a little bit about it while the argument was proceeding. If these were two motor vehicles, you then, I read plaintiff's argument, and I'm not sure if this is his intent either, that you would then go to the MACP. MACP would just have 250, so everybody would have the same policy limits. I might be confusing your question to Judge Kropkin during that. I don't think that should be allowed. We have the MACP for a reason, to cover claims that are not covered. They're the insurer of last resort. I do not think they are meant to be the insurer that picks up the slack if an opt-out has been selected and there's nothing left, so to speak. I do not think you should be able to stack with the MACP.
I thought Judge Cameron's question was about two motor vehicles.
Yes, I'm sorry.
One of which has a 250 cap and one of which is unlimited.
I think in that scenario, I would agree with plaintiff that you do have one might be your own policy, the second might be your spouse's, but in that instance, we have the pro rata split as well. So I don't know if it would come up. We were mostly concerned in the context of the MACP essentially being used as a alternative stacking source.
Right, but
in that scenario,
you'd agree with me if we accept plaintiff's argument with regard to the stacking argument, that this law would apply to two vehicles just as
I do agree
in
this
terms of the scope of the opinion.
Yes, I do agree this decision would have broad reach. And I'll let counsel for USA speak to that perhaps more. But I think that shows why we don't encourage stacking, because it would have that broad reach. I do agree with that.
Thank you.
Thank you.
Good morning, Erin Sedmak on behalf of USAA. So in over 50 years of no-fault law, never has stacking of policies been allowed, not pre-reform and not post-reform either. And there was an attempt prior to reform to stack policies to cover losses. And the court said, you cannot do it.
Outside of the PIP
No, in the
complex.
PIP context,
You have unlimited PIP. Why would you need stacking?
because there were still limited benefits, wage loss, survivor's benefits, and replacement services. So this is not completely new. And as we discussed, this is not limited to motorcycles. There's talking about everything. So this would have broad consequences. You cannot drop down to avoid the policy limit of the applicable policy. There is no statutory mechanism for it.
I may have missed this in your briefing, but are there any cases where stacking was prohibited in one of the areas you just identified?
Yes, there was the O'Hannison case. It's in
What?
our
I'm sorry?
brief. O'Hannison. They expressly said you cannot stack to cover actual losses. So do not be confused. This is a request for a change in the law that would be a seismic shift in the no-fault world.
Well, there was a change in the law
In
in
2019.
2019, and it was pretty seismic, and we're still sort of figuring all that out. And I mean, this is a situation where, You know, the statutory reform, part of what went into it was you should be able to choose whether you want more coverage or less coverage.
Exactly.
And here, with the motorcycle situation, you have a situation where the injured party, either they themselves or a family member, the resident relative situation, chose unlimited. And they cannot, under your interpretation of the statute, they cannot get the benefit of their personal choice.
That is accurate. So motorcycle insurance and car insurance are different. So motorcyclists can buy PIP coverage that is separate. It is not the no fault coverage because no fault is for motor vehicle accidents. So a motorcyclist, if is involved in an accident that doesn't involve a motor vehicle, they don't get any no fault benefits at all. So auto coverage is not supposed to be for motorcycle. Motorcyclists, the legislature, has come up with policy for motorcyclists. They do have some limited access to no fault benefits, but it is not the same as an occupant of a motor vehicle. And so when you choose policy limits, you are doing so in the motor vehicle no fault context. Motorcyclists come in.
But the choice that you make, I mean, the insurance follows the individual. And so
In
the
most
choice,
cases.
right? I know there are always exceptions, but the choice that you're making is if I am injured in a motor vehicle accident, I want myself or my family member, I'm willing to pay a higher premium. And in exchange for that higher premium, I want myself or my family member, if I or they are injured in a motor vehicle accident, to have unlimited coverage. That was the choice that was made here. And it seems like this interpretation that you're advancing would not allow the individual to have the benefit of that.
Not only my interpretation, but the way it's been for over 50 years. And the order of priority for motorcyclists did not change in 2019. It's always been this way. So before, granted, there was unlimited benefits, but the order of priority was the order of priority. And in fact, post-reform, this very issue was brought in front of the legislature in 2021, where a change in the order of priority was changed. So it would be more likely the motorcyclist that was injured would be looking to their own auto insurance policy. And the legislature rejected that for whatever reason. But that is the legislature's choice. And unless the legislature intended something different, that's what we must follow. And so their support for making this change in the law is really looking at the text in the following order of priority from 31-14-5. That language was in the act prior to the 2019 amendments in that section and the one that applies to occupants.
Yeah, I mean, I think they would say that they're not advocating for a change in the law. That it's just that the implications of the same law are now more interesting.
Understood. But that language is what they rely on, and that language was the same before the change. And when provisions of any law, which is reenacted, amended, or revised, so far as they are the same as those of prior laws, shall be construed as a continuation of such laws and not as new amendments. That language was never interpreted before to permit stacking. And the legislature is, of course, presumed to know the law when they make amendments. And so when the legislature went in and made the 2019 amendments and introduced policy limits, the legislature did not. Well, it was presumed to understand how priority has worked and always worked and has been interpreted. So if the legislature wanted to put in some mechanism for stacking policy limits, the legislature would have done so, but they didn't. So what do they take us on a tour of all sorts of different concepts in no fault law where there could be a pro rata distribution, or there could be a situation where a lower priority insurer has to pay. And yes, those exist in specific circumstances, none of which exist here. And I think it's particularly interesting that there was so much discussion about 31-14-6, because to me, first of all, they admit it doesn't apply, but it pertains to a very specific circumstance, right? Where if there's a policy with an opt-out, which would preclude the injured motorcyclist from collecting allowable expenses altogether, right? Not just be limited, But altogether, so the legislature was certainly aware of this. Then you look to other policies in the same order, and if there are none, then you drop down. Well, that would be totally unnecessary if the general rule was intended to be that you can stack PIP policies. It would be surplus nugatory language.
And this is another hypo where it's not this situation, but I think it was brought up in your opponent's brief, which is that a motorcycle has an accident with a motor vehicle. The motor vehicle takes off, so it's a hit and run, and you don't know who that is. And then you do look to your personal policy as the next in line, right?
No, you don't. Not if it's a motorcycle. There's a whole order of 4 different ones. And the first 2 are the motor vehicle, and then it's the operator, and then it's the owner of the motorcycle.
So, right. So the motor, so A and B are the motor vehicle that was involved in
Right,
the
but-
accident. Okay,
yeah.
so let's say that motor vehicle takes
Yeah, the
off.
operator is not necessarily the owner of or the injury. It could be a passenger on a motorcycle, but
Oh, I see. Yes,
Yeah,
right. Okay.
so-
But let's say if the motor vehicle involved in the accident disappears, then you go down,
Right.
don't you go down to C or D?
yes.
Yeah. So
Because
then
it's not identifiable, but I want to address that. I'm glad you brought that up.
I mean, it seems odd, right? That you would,
And that's the exact change that was presented to the legislature in 2021, and it didn't pass.
right? But it's
So-
very hard to know what that means when something doesn't pass.
But
I mean, we've
the
got
language of the
we've
order
got
of priority is certainly clear, right? We know what that says. And so in Griffin, I just want to clarify, because it was brought up in plaintiff's brief several times where they have this quote where, it would be absurd, and then they kind of paraphrase it, it'd be better off with a hit and run. So we represented the MAIPF in Griffin. That was our case. I know it very well. Had nothing to do with policy limits. That quote has nothing to do with policy limits. That had to do with whether or not an insurer was identifiable within the 1-year statute of limitations. And when it's absolutely clear they're not identifiable in a hit and run, then they would make a claim to the lower priority insurer who would have to pay. And there was a question because the highest priority insurer was eventually identified after the 1-year statute of limitations. And that's what they were discussing, whether or not they still had a claim to the lower priority insurer. So it really has nothing to do with policy limits. I understand the concept, but again, we're going back to the idea that the order of priority is what the legislature set. And, if the legislature intended, when the legislature was fully aware that policy limits were in effect, for there to be the ability to stack, they would have put something similar to 3114.6 into the act, and they did not. So, and no concept that they talk about applies to stacking. It just doesn't. So there's no statutory text. There's no case law that says, yes, you can stack. There is case law that says, no, you cannot. Right? But, for example, insolvency. That's a highly regulated thing, insurance insolvency. Chapter 79 and 81 deal with that. And without getting into the details, I'll just say that, yes, generally, when there's an insolvent insurer, you have to look to all other sources of coverage. And that would include solvent insurers in the order of priority.
Can I ask you another question about subsection 5? What do you make of the fact that it says that you claim benefits from insurers, plural, in the following order of priority?
That's how it has always been. So if there is no insurer in the first order, you go down to the next. If that one's not identifiable for some reason, you go down to the next. That is how it has always worked. And that makes perfect sense. With subsection 6 too, the idea that you can move down the order of priority by exhausting limits, you've always been able to move down the order of priority in certain situations. That doesn't mean you could stack policy limits or stack policy benefits. You've never been able to do that, right? There's no mechanism for that, except except the ability to skip over an opt-out policy which the legislature was very aware of. So they were definitely aware of the fact that policy limits would affect this order of priority. But sorry, I lost my train of thought. But there's never been the ability to stack, right? So that's a very different thing. It's like saying, well, there can be coordinated benefits with medical. Okay, well, you get a discount if you decide to make your medical primary, because then your car insurance doesn't have to pay as much, right? So you get a discount. That's not stacking PIP policies in the order of priority. I mean, there's no statutory mechanism for that whatsoever.
Sorry, Judge Cameron asked a question earlier about the implications of this outside the motorcycle,
Right.
motor vehicle situation.
So
do you want to address that?
yeah, so they're saying, oh, you don't go to the MACP. And I would agree, but also, why is their argument stop there? I mean, if we're just going to make things up and write in language to the act, it kind of confuses me. Does that mean that the MACP becomes the default excess insurer for extra $250 for everybody, or everybody who doesn't have a unlimited?
Let me reframe it just to maybe this wasn't what Judge Cameron was asking, but let me ask it my way, I guess. Two motor vehicles collide. One motor vehicle has a $250K cap, or the operator, the injured party from one motor vehicle has a $250K cap. Someone else driving the other motor vehicle has an unlimited cap. What implications does this case have for something like that?
Well, if there's two insurers in the same order, it would be the same. But a lot of times now, I mean, it depends a little bit on what kind of vehicle they were in and whatnot. But a lot of times now, again, you go straight to the ACP if there's no personal policy that under 4, which is the most common. So would that mean that you get to go to the ACP? Maybe they say no, because they're not expressly in the order of priority.
We're not talking about, let's be crystal clear. We're not talking about the signed claims.
Okay, but
We're not talking about that. The question is, you have two vehicles. If you lose this case, all right, and stacking applies, is it limited to the motorcycle arena, or would it be extended to motor vehicles, which is the more frequently occurring event?
yes,
That's the question.
yes, I do, because there's nothing that says otherwise,
So
right?
can you walk us through and I know we're putting you on the spot, so it's a little hard on the spot, but I just, could you walk us through a scenario where, and I guess where I'm coming from is, and I think I talked about this before. If you make your own personal choice to pay higher premiums for an unlimited policy, it makes putting aside this text of the statute, it makes some sense that you're expecting you would get the benefit of that. That's a little different from a situation where you've made a choice to limit coverage because you want to pay less. And then are there situations where someone nonetheless goes and gets unlimited coverage?
Well,
And
if
what
you
would those
are
look like?
a passenger, say in a vehicle used in the business of transporting passengers, you generally look to the insurer of that vehicle, not your own. So if maybe that one didn't have complete coverage, the next insurer in the order line of priority would be your own personal insurer.
But if you paid for the unlimited, that's similar to the motorcycle situation.
If you did, but it's not, I mean.
Or if your family member did.
Facts differ in every accident. I mean, there's one thing, there's no typical situation to follow and crazy things happen. So there's always, there is a situation where you could be relying on someone else's choice. But the legislature understood that. And that is the order of priority, right? If there was no such thing as the order of priority, then every single policy would be on the hook to pay, right? But they're not. That's what the order of priority does, and it's what it has always done. And so when the legislature went in and introduced policy limits, they did so for a very specific reason, to lower the cost of car insurance, right? Because we have this ballooning cost and people were going uninsured, which is bad for them, right? And bad for everybody. And so they tried to bring it down. If you get rid of policy limits, if you make them, basically inapplicable, and now every insurer that sells a policy is in the order of priority, that doesn't save money. And subsection 6 and actually subsection 2 expressly put the client assigned claims in the order. And I know we're talking about policy limits, but when they're in the order of priority, it implicates them too. So it would have very broad effects. The No Fault Act, it's like a sweater. It is all strung together. If you try to change something, it affects a lot of other things. And this would be a seismic shift in the law.
Got it. All right. Thank you very much.
Thank you.
Any rebuttal?
On my comments to the USAA portion of the case, I want to address the Ohanneson decision. Counsel suggested that decision stands for the proposition that there can never be stacking. The problem with relying on that case is that
the statute was removed.
exactly
Right.
So that the statute sheet that case dealt with was 3115.3, 2018, and that statute read, "A limit upon the amount of personal protection insurance benefits available because of accidental bodily injury to one person arising from one motor vehicle accident shall be determined without regard to the number of policies applicable to the accident." That statute doesn't exist in that form today. So Ohanneson, in my mind, is not at all controlling on this situation.
And what
Judge-
about the nugatory argument about subsection 6?
Happy to address that.
I'm remembering which subsection we're talking about, right?
The argument is that what's the point of subsection 6 in
If
3114?
you're allowed to,
If the laddering we're suggesting
Right.
is the law of the land. Here's the reason. Subsection 6 is needed to address situations where there isn't PIP legitimately because of an opt-out. So 3107D is a person who has Medicare who can choose no PIP. The statute has to speak to what happens in that circumstance. The laddering down we're suggesting is situations where there are multiple policies with PIP, but the limits are different. So 6 addresses a different situation that isn't here, but it's still needed. It's not nugatory. I want to address you made the comment, Judge Karak, and I think you said it exactly right. The implications of this are different. But this idea that coverage and priority are distinct, that's not new. And a position we're advancing is not new. USAA conflates them. And they do that likely because our jurisprudence has, I think, done a lot of that. But now that we have a situation where we have to deal with different limits and what that might mean, we have to be, I would say, have a greater amount of attention to those concepts as being distinct. Dye versus Esurance says very clearly, courts should not do that. USAA relies very heavily on the notion that priority answers the question of coverage, and I would submit it simply doesn't. Lastly, Griffin. So Griffin was a matter where there would be no reason for Trumbull in that case to have any liability if coverage and priority were the same thing. In that situation, the only reason that Trumbull, the motorcyclist personal care, had liability was because multiple policies applied. So the logical underpinning of that decision is absolutely the same as what we're advancing here today. And I would argue is the logical underpinning for pay and chase and has been the law for many, many decades. So the teaching of Griffin is that simply because a higher priority carrier exists, as it did in that case, Harleysville was admitted to be higher, they just simply weren't part of it. Now, if their argument was true, that priority and coverage are the same thing, it would be a dismissal as to Trumbull because they're not highest. But the court didn't do that. Now, the court did undertake an analysis of whether or not, through reasonable efforts, Harleysville could have been identified. But there would be no reason to rest liability with the second in line carrier unless there's this simultaneous coverage obligation that exists in the law. And I would submit to the court that it does. It has always existed. But now we have to confront it on a more forward way because of situations like this. So unless the court asks questions, I'll rest.
All right, thank you all very much. Very interesting. You've seemingly done the impossible, making PIP interesting. So thank you for that. Turning now from item number 23, I think we're going to jump forward to a little out of order to item number 25, Mayor versus Farm Bureau, General Insurance Company of Michigan, consolidated cases 371080 and 371175.
Morning, Your Honor. Ryan Duffy on behalf of the appellants, Bronson Healthcare Group and Mary Freebed.
All right, you go right ahead.
I'm not going to repeat a lot of what my partner and fellow counsel just went through, so I'll make it somewhat brief. Try to clear up how I would have answered, I think, some of the important questions the panel just asked. But this is a very important issue. And it's critically important that the panel gets it right because there are a lot of cases I know firsthand that are going to come up, that are coming up into the Court of Appeals on this exact stacking issue. And it's real important for people like Mr. Mayor, who was a public safety officer who purchased unlimited for his household on his way to work on a motorcycle. He properly insured and was hit by someone who was intoxicated who selected 250. And when this reform came out in 2019, it was hailed that you would now, as a citizen of the state, have your own choice. You would get a choice and you get the benefit of your choice. Without the stacking, which we think there's a basis for, Mr. Mayor is robbed of that choice. He chose unlimited and is not able to access that because of how the statute is being interpreted. So I would say it is important for a lot of reasons. The reason why it's now coming forward, as has been said, is everything was done in the context of unlimited prior to 2019. So stacking really wasn't an issue. I know counsel for USA in the previous case had said, well, it was because of work loss benefits and replacement services. But statutorily, those are still limited in terms of duration and the amount. So it was, the anti-stacking was windfall. They didn't want anybody getting a windfall from two policies that gave the exact same amount of benefits. So that was where that context came from. But here we are. I want to get right to the question about, does this have implications if it's just motor vehicle accidents involved and not a motorcycle? I think if you read 3107, it says, except for sections 2, 3, and 5, this is how you would pay, right? You either get your own policy, your spouse's.
3114.
I'm sorry, 3114, yes.
Okay.
Excuse me. You get your.
I made that mistake before, and so I'm trying to make sure I'm on the right section.
But you go to your own policy, your spouse's, or family members. Now, if you get in an accident, such as, I will give the court a quick example. Maybe this will help, maybe it won't. I live with my father. My father doesn't listen to me because he never listens to me and purchases 250 and I purchase unlimited. One of us gets in an accident. We are at a pro rata time where both policies cover whether it's me or my father that get in the accident, and they're paid out pro rata. There is no stacking there because we both live under the same house, and the language, I would presume, of the policy covers us both. Where you go to section 5, it is distinct. You keep going down, and a motorcycle is not required to have PIP. That's why you had to go to section 5 to find PIP when a motor vehicle was involved. And if you look at the language and the addition of the one section 3107C6, it allows for stacking. Now, would you get to the MEIPF?
I apologize to interrupt you, but could you explain the pro rata thing? And I know it's not this case. We're just trying to figure out the implications.
Sure. I believe how it would work is if I got in an accident in my household and there's two policies from two different insurers, they pay out pro rata. So I think they would start paying out, if it was 250, whatever the bill came in, the unlimited policy would pay half and the 250 would pay half. And then once the 250 is exhausted, I would still be covered under the law, under the unlimited policy that's in my household. That's not stacking, that is paying pro rata. Section 5 allows for what we believe and what we're arguing to the court, stacking. And those policies aren't purchased.
If you both had 250, you do pro rata, but you just get to the end of the 250 and that would be gone.
That's how I would view it. That's how they're paid out pro rata. That's been brought up a couple times in the previous argument. but it's stacking. I don't think this has, if this panel were to find that you can stack in a motorcycle because it's under a specific subsection that is referenced in 3114, it does not have the implications that I think some of fellow counsel from the other insurers would say it does. And it is going to rob people of choices, such as in this case with our facts.
Well, sometimes it'll rob people of choices. Sometimes it'll be a windfall. It just depends, right?
I don't know what a windfall would be other than a windfall. Let's say that in our case, the driver of this car, Mr. Todd, was on the motorcycle with his 250 and Mr. Mayer struck him or was involved in that accident. Now Mr. Todd gets unlimited. I guess if that's what you're saying by a windfall.
Well, no, I'm referring to if what you're seeking is a policy for $250,000 that you exhaust, and you can then enjoy the benefits of an unlimited policy that you didn't pay for. That would be either a windfall. You could call it call it something else. I'm not going to call it that, but you could call it something less generous. For that person who could enjoy an unlimited policy and yet never have to pay the premium for it.
But the law already allows for that, Your Honor, in a motorcycle accident, such as, like I said, if Mr. Mayer, who purchased unlimited, struck Mr. Todd, who only had 250, I think the law would allow for that. I'm sorry, if he didn't have any coverage at all, you go down.
Right. Yeah.
Yeah, he would go down. Yes, I'm sorry. If he didn't have any coverage at all, it would go down to, he would already enjoy the unlimited no matter what. He would enjoy Mr. Mayer's choice in that case.
Here, as a resident relative, he is arguing that he bought and paid for, or his parents did, an unlimited policy.
That's the previous case. Our case's facts are a little different in that our patient here, or Mr. Mayer, that fellow appellant, he was a named insured on the policy.
That's exactly why we should have had a case or two between these two cases, so I don't conflate everything in my mind. All right, go ahead.
The arguments are the same, Your Honor, but in this case, we would say the facts are a smidge different. We're not talking about effective election, and Mr. Mayer purchased the policy for himself.
I think we know this issue pretty well. Is there anything else?
No, that's why I didn't want to waste the court's time. So,
got it. All right, thank you very much. Appreciate it.
Been appearing on behalf of Mr. Maher. I am not endorsed for oral argument, but I am here just to answer any questions that the court may have.
Did you have a different answer to this question about the pro rata?
I do not, but I think it's very important to understand that this will only have implications to the motor vehicle versus motorcycle accidents. That's it.
Why that?
And that's because of the way that the statute is listed. 3114 is devised. 31141 talks about you look to your own policy, you look to that of your spouse or a resident relative. It's only, and it says right in there, there's except as in 2, 3, or 5. 2 deals with a vehicle that is a transportation vehicle type of thing. Then you would look to that insurer. 3 goes to the insurer of an employer vehicle. And then 5 is for a motorcycle. So that's it. Unless you fall within one of those exceptions, you're looking at your own insurer. And that's it. So this priority issue that we're talking about here is limited to the motorcycle versus motor vehicle issue.
Okay. Anything else? All right. Thank you very much. Appreciate it. Thanks for being here.
Good morning, and may it please the court, Mark Soul on behalf of the Appellate Appellee Farm Bureau. I have never had this experience where I got to hear the questions in a preview beforehand. So I'm going to do the same thing. I'm going to try to answer.
Expectations are high.
Those questions. So first thing that I saw in the gallery was there were some questions that presupposed if we had just right out here in Ottawa, like 2 cars crash, that PIP coverage would ever cross between the two.
They don't.
It would
right?
not.
Okay.
So
it's only if you live with somebody who has a different policy that you might be able to go get something from theirs.
You would never leap to the other car, though.
Right.
You would always be on your own insurance, which
or in your house.
In your household, sure. Yeah. So the question that I think kept getting asked over and over and over again is, well, what are the consequences of what the appellees in this case are arguing? And I agree with Ms. Sedsmack. These are earth-shattering consequences, and here's why. There are 3 reasons in 3114.1 why you would not go to that basic order of priority, spouse, resident relative, or named insured. First one is you're in a vehicle in the business of transporting passengers. There's a whole bunch of exceptions to that, but we all kind of know what that means. Second one is an employer furnished vehicle. So I'm going to give you a hypothetical on that I think can answer your question. You got a guy right out here delivers beer. So he drives a beer truck every day. Every day he pulls up to a gas station. Not only is he driving, but he's loading and unloading constantly, right? So that's covered under the no-fault statute too. Company he works for is cheap. They put $250 coverage on the beer truck. His personal insurance on a car he drives once a month is unlimited. What they are arguing in this case is that he can stack that personal unlimited coverage on top of his beer truck coverage, and that insurance carrier did not write that risk. Not under this statutory scheme. They wrote a risk of a family motor vehicle, and instead they're getting a beer truck that drives up and down Ottawa all day and has a guy loading and unloading. That's the difference, and that's why you can't stack.
But even in that situation, the delivery person is making a choice that they'll pay higher premiums in order to have unlimited.
If the insurance
And
carrier,
I think what you're saying, and I mean, this is a fact of the world rather than in our courtroom, right? But I think what you're saying is that if that's the case, those premiums are going to, for unlimited, are going to be significantly higher than they are.
presumably, they would be way higher if the insurance carrier even knew about that. So what they are presupposing to do is have.
You don't think they've thought of this possibility, you know?
Well,
before
they
today?
certainly, I can tell you they ask those questions in applications and they are very rarely answered accurately. It's in the wash of the back and forth. But the way the statute is set out, you can't stack. And I think Ms. Sedgmack hit the nail on the head. If you look at 31-14-6, they laid out a situation whereby you would do that ladder and then they stopped. And if they wanted to, they could have added in a provision that either reformed 31-14-5 and said they go in a different order, which as she indicated and I indicated in my brief, the legislature tried, but they didn't do that. So with that, if the court has any other questions, I'm happy to rest on the briefs.
I don't see any questions. Thank you.
Okay. Can I actually, before you go, the implication of your position though is the hypothetical for the hit and run is correct, right? That there could be some people who might be better off with a hit and run situation than if they were able to identify the person who hit them.
Certainly they would. And that was a legislative decision that was made.
I mean, if that, I mean, yes, there are a couple of ways of thinking of that, which includes what your inferences are from that. But it does seem to me that the incentives to identify the vehicle that was involved in the accident might get warped a little bit if the individual who is injured has an unlimited policy.
They might, and I think as Judge Cameron indicated, the exact opposite could be true, where you could get a windfall as a result of this. And that's just sort of the way the cookie crumbles in this instance.
What's the windfall situation?
Well, let's say hypothetically, if you're a motorcyclist and you have a personal policy where you buy the cheapest insurance, you buy $50,000 in PIP coverage, and then you get hit by a car with unlimited coverage. You get unlimited PIP coverage despite not paying a premium for that coverage, but you get it from the insurance carrier for the car. And in that instance, the insurance carrier for the car knew what they were writing. They knew that if my insured goes out and runs over a motorcyclist, I'm going to be on the hook for unlimited PIP. That's not what Farm Bureau knew in this case. Farm Bureau knew in this case that if our guy goes and gets on a motorcycle and gets hit, it's the car that hits him that's going to cover his PIP. So we did not write a premium that covered this particular instance.
You don't think they knew that we'd all be sitting here in a case like this trying to figure it out and maybe accounted for that in their actuarial?
I am not
decisions?
an actuary myself, but I would not want to have to make actuarial decisions based on potential court outcomes. That would be difficult.
Okay, thank you.
Thank you very much.
Any rebuttal?
Very, very brief, Your Honor, as I know we've beaten this to death. I would say under Section 3 with the employer example, I don't read the statute under 3114 to even see how a mechanism where you could stack there. It doesn't talk about going to the next in priority. There is no priority. It goes back to the beginning, says it as except to exception 2, 3, and 5. Also, there's nothing in the record about what risk Farm Bureau wrote for Mr. Mayer. So I would say that they did or did not write the risk of him riding a motorcycle and being struck by another vehicle that had less coverage. There's nothing in the record to indicate that's what they knew or didn't know.
But so you're saying on the employee coverage, and also was there maybe one of the other exceptions, the commercial carrier situation, that there wouldn't necessarily, I mean, maybe that gets decided later, but there wouldn't necessarily be stacking because it doesn't have this order of priority that is in subsection 5.
Yeah, exactly. There's no language that would revert it back to your policy there. That's how we would read the statute. I think the court can decide that this is a very narrow part of the statute and section of 3114. Unless you have any other questions, Your Honor, I
think so. Thank you.
Thank you.
All right, that matter is submitted. Thank you all for being here. Do we need a break? You good? We can come through if you're good. Good, okay. All right. 2, 1, 3. Item number 23, estate of Frank Anthony Karwalski versus Vicky Hamlin Rogers. That's item number 371980.
Morning, Your Honor. Elliot Blumberg on behalf of the plaintiff appellant, the estate of Frank Karwalski. I've traveled many miles today to get here today, and I appreciate the opportunity to present our argument today. I will presume that the court has obviously reviewed the briefs and are fairly familiar with the facts of the case. I would like to highlight some of the issues. This is an appeal from a granting of summary disposition by the trial court as it related to claims made against the conservator guardian in this matter. The court determined that there was not a factual basis for the case to continue, that the evidence that was supplied to the court was not sufficient. We believe that that court made clear error in that regard. The conservator was appointed by the Otsego County Probate Court. She had not ever been appointed in that position by that court before. The appointment did not require her to post a bond, which ultimately became an issue in this matter. In her brief tenure as the conservator in this matter, she was required to do those things that a conservator is required to do, including preparing an inventory. In her late inventory filing, she failed to disclose the existence of a rather substantial coin collection.
We've got the facts down cold.
Okay, so we believe that as the conservator, she had a fiduciary duty to act in a prudent manner and to not dissipate the assets of the estate. Without knowledge of any of the beneficiaries, she took the coins from the safe, didn't inventory them, so there was no record of what she removed, and she took them to a coin dealer in Petoskey, Michigan. The first issue was her failure to inventory those. In her deposition, she acknowledged that that was a mistake and that she was fairly negligent for not doing that. The other issue is that she sold these coins without the need of doing so. There was sufficient assets in the estate to maintain Mr. Karwalski in his home, as well as pay for the health care that was being provided by an outsourced third party. She sold the coins and claimed that she returned the remainder of the coins because she hadn't sold them all, put them back in the safe. She continued to carry out her duties in a manner that I think were not appropriate. And when complaints were filed with the probate court appointed a master to review the actions of the conservator. That report was fairly critical and recommended her removal. She had failed to do a number of things that she was required to do. Before the court could actually take the steps of having her removed, Mr. Karwoski passed away. And it was after his passing that it was discovered that there were no coins in the safe and that she failed to properly pay the bills as that was required. She was negligent in almost every aspect of her performance. When we filed this lawsuit, we filed claims for breach of fiduciary duty, and we alleged that she had converted those coins to her personal use. Summary disposition was filed, 2.116C10.
I'm going to stop you for a second. How did she convert them to her personal use? I mean, she has them, she sells them for a certain value. She gets a receipt, and that amount of money is put in the estate. And so how does she convert them to her personal use? And I know there's this argument about the coins in the safe, but there was no evidence in the record that indicated that she took those coins. And so how is she converting it to her personal use?
Certainly, and we believe that there was circumstantial evidence. She was the last one to have taken the coins from the safe. The coins had never been seen again once she sold them. The action of not inventorying them is a form of negligence. I mean, there was no record of what she took other than what she claimed she sold. And she testified that she had returned the remainder of the coins to the safe. Nobody ever saw the coins again. Our argument to the, I'm sorry.
In this home?
Yes.
Did other people have access to the safe?
There was Mr. Karwoski's son, who was mentally disabled, had a number of issues that would not have had access. There are really two issues relating to the coins, and I think I've tried to make that clear. Perhaps I haven't. The failure to inventory is a breach of fiduciary duty. Secondly, she dissipated the estate by taking them to a retail sale, a coin sale, for probably less than what they were worth. Mr. Karwoski had documents that showed they were worth.
Probably is a big number, big word there. It was probably worth less than what she got for.
No,
you said probably. So what, in terms of the evidence that the trial court used in making its decision, you're correct that there was not an inventory done as it required. But what evidence do you have that the money she obtained for the coins was under market value?
Mr. Karwoski had a number of documents that he kept which valued the coins from time to time.
So the appraiser you're using is the deceased.
That's correct.
Personal assessment of his evaluation of his collection.
He would daily go online and look to see what his collection was worth. There were documents, the court didn't accept those. I tried to present them at one point, but
How is that admissible?
it wasn't. And I'm not saying the court was wrong in excluding that. I do think that the court improperly excluded the master's report because that was a document prepared in the ordinary course of business by the probate court. The trial judge wasn't interested in what the master had to say. The master, again, basically substantiated her malfeasance and suggested her removal. That never happened because Mr. Karwoski passed. The burden of proof on these C-10 motions is that all the allegations and the evidence is supposed to be reviewed in a light most favorable to the non-moving party. And again, I think the trial judge didn't apply that standard because if he did, he would have said, these are questions of fact for a jury. That's what we argued. And that's what I'm suggesting and requesting that you ultimately do today is that you remand this matter back to the trial court to allow for further proceedings so that we can have the triers of fact to determine whether there was a breach of fiduciary duty. We pled it properly. There was sufficient evidence for the court to at least make the determination this is a question of fact for a jury. That was taken away from the estate. So that's our position and our request. If you have any questions, I'll be happy to try to answer them.
I don't see any. Thank you.
Sure.
Okay. Counsel, go right ahead.
May it please the court. Thank you for allowing me to appear via Zoom today rather than having to travel from Petoskey. Amy Stikovich on behalf of defendant Appley. I believe that my brief that I filed addresses everything sufficiently that counsel has argued. Just a couple of points that I want to reiterate. A breach of fiduciary duty claim has more than one element. There's duty, breach, and damages. There has to be a showing that the estate or the ward was somehow damaged, and that is wholly missing in this case. There was no expert disclosed by the plaintiff. I filed the motion after discovery had closed, and the trial court properly found that this element wasn't proven. And while the burden is on the move on, initially it shifts to the respondent pursuant to MCR 2.116G4 that they have to present some sort of admissible evidence, and that again was not done in this case. I think one of the judges asked about access to the safe, and counsel replied that there was a mentally disabled son who was living that did not have access. On the contrary, plaintiff testified in her deposition that both she had access and her brother who was living in the house. So I don't want to belabor any of the points. I'm happy to answer any questions.
All right, I don't see any. Thank you.
Okay, thank you.
I'm sorry, there is one.
Yes, can I just ask one question?
Sure.
On the treasure trove receipt, which
Yes.
is in the record, there are three monetary values given.
Yes.
One is 105,720, I think. One is 90,000 and one is 80,000. The lowest number obviously is 80,000, and that's for cash now. And I believe the record shows that's what was agreed on.
Correct.
Why doesn't the fact that there are two other numbers there create a question of fact about whether selling it for 80,000 diminished the value of the estate?
Because the value was 105,000, but when you're selling the coins, the place you're selling them to is obviously going to take a cut of the profit. So the 90,000 was if she would have sold it on consignment, and the 80,000 was the cash value.
And so, and I think there's some evidence about the reason why it wasn't consignment is because they needed the money now or something like that. And because no one else testified that wasn't true, your position is there's no question of fact about the difference between the 80 and the 90, or whether they could have gone to a different, treasure trove's competitor down the street or something like that.
Right. Exactly. There was nothing to contradict that. And as the trial court found that there wasn't, I think the trial court succinctly stated serious allegations, but a serious lacking of proof.
Thank you.
Thank you.
All right, any rebuttal?
Just briefly, thank you. I appreciate Your Honor bringing up the issue about whether the 80,000 as opposed to these other values was appropriate under the circumstances. Part of the argument we made to the trial court was, besides the fact there wasn't a need to liquidate, the conservator made no efforts in advance of taking the coins to get an appraisal done. She had told the personal representative of the estate subsequently that she just took the coins there to get it appraised, not to sell them. Well, she sold them without knowing what their real values were. She didn't go online. She didn't go to a third party to determine them in advance. And moreover, she went to a retail sale place where obviously you're not going to get the full value of the asset. These are all things that I think she was required to do in her capacity before she unilaterally made the decision to liquidate. So again, we believe that that's a question of fact, whether she acted appropriately and whether she breached the fiduciary duty owed. Thank you.
All right, thank you very much. That matter is submitted. Turning now to item number 24. Canal versus Township of Glen Arbor, that's 364833.
Morning, Brothers. I'm C. Nemus, appearing on behalf of the appellants, Richard Connell and Julie. Your Honor, I would rely on my brief filed in this matter. However, there are some points that we would like to make pretty clear. Our clients purchased this property in their 20s in July of 1977. They are now in their 70s, and they purchased it for the purposes of building a retirement home. They live downstate. This property's up north. They had no knowledge that there was any allegation that the property was non-conforming in any way. Not until 1996, when they applied for a variance. At that point in time, they were told that there's a 3-acre minimum, 131,000 square feet. That was news to them. And the township said, you need to apply for a variance. Ultimately, they were denied. And they've gone back and forth now for a number of years. And more recently, they filed this variance request. And basically, the township this time said, look, we think that your predecessor in ownership, or your predecessor in title, gave you a deed or you bought on land contract a parcel that was defective. Our ordinance at that time required 3 acres and you didn't have it, so tough luck. And they relied on the case of Johnson v. Robinson Township. But before we discuss a variance, it's a variance from an ordinance requirement. It's important that we understand what the ordinance requires. This property was zoned agricultural. Article 9 of the township's ordinance says that residential use in accordance with R1, R2, R3, and R4 under Article 5 is a proper use of this property. That Article 5, the only difference between R1, R2, R3, and R4 is the area required. R1's 15,000 to build a home, 15,000 square feet. R2 is 30, R3 is 45, and R4 is 60. Prior to the amendment in 1975 of the township zoning ordinance, the minimum square footage was 20,000. The township would have us believe that the square footage jumped from 20,000 square feet to 6 times that amount, 131,000 in 1975. I proposed, and I raised to lower court level, that doesn't make sense. That the ordinance says that these R1 uses with these square footages are permissible. The only reference to 131,000 square feet is further down in the ordinance. And further down in Article 9, it says that, and I quote, each single-family dwelling with its accessory buildings shall be located on a legally described parcel of land not less than 131,000 square feet of area if it is not built as part of a main farm dwelling. So, it's confusing at best. It doesn't blanketly say 3 acres. In fact, in 2023, the township amended its ordinance. And they amended its ordinance to say any use in agricultural property requires a 3 minimum lot. Now, in addition to this, I think it's the crop case, for example, states it best. The most foundational, constitutionally protected property interest under Michigan law is a landowner's right to reasonable use of his land. A zoning ordinance may regulate land use, but it can't take away all the land's reasonable use or require the land to be used for something unreasonable. Now, in 1996, when Connells applied for a variance, the National Park Service issued a letter opposing the request for a variance. And they finished their letter with the quote, "We believe the Connell's tract should be protected for the use and enjoyment of all people." Therein lies the difference. Connells want to make reasonable use of their land. The Park Service wants it no use of the land. And even though the township and this enabling statute, 1982, 5 years after our clients purchased the property, the Park Service, MPS, expands into our client's neighborhood, where he lives, expands to where the property is. So the township is saying, yeah, we have, according to the enabling statute that the federal government passed and all that when they created this extension of the park, that the township should cooperate. And you read that throughout the township's brief. But cooperate, and in terms of zoning, doesn't mean prohibit. And that's effectively what they've done. They've prohibited the development of this property. Now, the lower court said that it found Johnson v. Robinson Township to be controlling. That case is completely different. In that case, it was a frontage case, width of a lot, 99 feet. Grandfather, father, son come together to start partitioning lots. In that case, the parties were related. They all knew each other. In the Connell case, there's no relationship between the Connells and the person who originally developed this property. In the Connells, they have 2.25 acres, and the township's claiming it's a minimum of 3. Further, in the Robinson case, Johnson v. Robinson, the mandate in the ordinance is clear, 99 feet. Not so clear here.
And your brief does an excellent job pointing all of this out. Is there anything new you want to add? I think I'll tell you, just so that the court realized the significance of what happened. The township is saying, look at, the self-created hardship happened to your predecessor in title. When your predecessor in title created this defective lot, that is the self-created hardship. And I would propose that the self-created hardship was really something that started in 1982 when the Park Service moved in. When the Park Service expanded to that area, our client was no longer able to acquire property from a neighbor if in fact he needed an additional 0.75 acres. All that was cut off. And our clients were without knowledge. They lived downstate. They paid taxes on this property for 47 years. That's all I have at this point. I'll rely on my brief. I appreciate it. Thank you very much. Appreciate it. Thank you.
Judges Todd Millar representing Glen Arbor Township. As you've indicated, we briefed this quite well, I think, on both sides. And so I think that there's quite a bit of information in there. I'm going to try and just keep it at a high level perspective.
What can the landowners do on this property?
Pardon?
What value can they obtain from this property?
So the value that they can maintain from this property is they could keep it vacant if they want. They could put it into a nursery. They could use riding stables. They could do mining. They could put in a cemetery, an ice manufacturing plant.
I'm sure Glen Arbor would love to have that on this lot.
Yeah, I'm not arguing that that's a really good use of the property, but it's not a situation where there's absolutely no value that can be gained from this property.
You'd agree if all value was eliminated?
Then we got a problem. Yes, exactly.
Okay.
The problem here, Your Honors, is that as appellant's counsel indicated, they didn't know what they were buying. And they didn't know the zoning rules that applied to what they were buying. And they didn't learn that until 1996 when they tried to do something on the property for the first time. But yet the rules for zoning with respect to this property were set in 1975. They could have called up the township before buying this parcel of property and say, hey, what can we do on this parcel of property.
And the split in the lot was split into different parcels. That was after 1975?
That is what we believe the evidence that was presented to the ZBA establishes, and it relies predominantly on the assessor's information that was supplied, wherein it was indicated that this parcel doesn't show up on the tax roll until 1979. And that strongly indicates that it was not split, and the parcel that the Connells purchased was not created until after the zoning ordinance was amended in 1975. They got 2.25 acres. They say, we don't know what that means vis-a-vis the 131,000 square feet that is stated in the ordinance that is required to be able to put up a residential structure. 43,560 square feet in an acre. Multiply that by 2.2, you come up with 98,010 square feet. It's not 131,000. They just simply were uninformed as to what the zoning ordinance required and what they could do on this property. And that has never been and should never be the basis for obtaining a variance, such as what they're asking for, because then everybody could come in and say, well, I didn't know I couldn't do that on my property, therefore you've got to grant me a variance in order to do it. And that's never been the law and hopefully never will be the law. We would ask that you uphold the ruling of the Leelanau County Circuit Court in upholding the determination by the ZBA and deny the variance.
All right, thank you.
Thanks.
Any rebuttal?
Just briefly, Your Honor. Pretty clear that in Johnson v. Robinson, the issue was density. In other words, we want a 99-foot wide lot because we can't have houses stacked on top of each other. In this situation, the way it stands right now, there's one lot. Density is not an issue. You're not crowding any neighbors. It's all about prohibiting a reasonable use of the property, which is residential. That's all I got. Thank you.
Okay, thank you very much. That matter is submitted. Turning now to item number 25. I'm sorry, you're right. We covered 25 already. Turning to item number 26, which is adjourned, 27, which is In re Pettiford Minors, consolidated cases 374027, 374884. Yes, go ahead.
Thank you. Taylor Anna Furvento, P number 83907, appearing on behalf of appellant, respondent father at the trial court level, Mr. Isaiah Pettiford. May it please the court.
Yep, go ahead.
I have previously submitted a brief and I stand on my previously submitted brief. I can summarize and emphasize the most important points of that brief here. Or if the court would prefer, if the court has any questions or unaddressed issues from my briefing.
Standing.
I'm sorry.
Standing.
Standing.
Can you cover standing?
Yes, standing to bring the appeal.
Yeah, because I mean, the issue you raise, if I remember correctly, you were raising that make sure I have the right case.
Different case.
Oh, for goodness sakes.
Your issues are reading the petition to the jury and admitting the no contest plea.
Yes, that is correct. Those are the primary.
Those are the main issues. Yeah.
I don't have any questions. Do you have?
I don't either.
No.
Thank you. I do appreciate the court's time. And I just again emphasize the statute 403 prejudice. It is danger of unfair prejudice. That is the biggest concern when it comes to evidentiary.
Okay. And that's on the admitting that he had the no contest plea previously. That's
yes. Yeah. And as well as a reading of the petition.
Is that right?
Yes. On pages 8 and 9 of my brief, I identified all of the things contained in the petition, which no witness testimony or evidentiary testimony was offered during the trial itself to support.
So why, I mean, as long as there's a clear indication that the petition is an allegation, as opposed to the evidence. Why is that unfair prejudice?
Your Honor, the court rule states, and I can grab the court rule, that it is in the purview of the defense whether or not the petition is read to the jury.
Right.
It is unless waived. That's MCR 3972B2. So the unfair prejudice there, to an extent, it's the right of the defense. And in this particular situation, most of the time the standard of practice at the beginning of a jury trial is the court would ask the defense if they waived reading of the petition, and generally
Generally they do, I guess.
Generally they do.
Okay.
As having done trial work for 4 years in these, I would say that that is the general course of action. But at the end of the day, it's
For the reason, like, we don't want them to hear this stuff.
Exactly.
Okay.
Exactly. And again, you could have a curative jury instruction. You could bring those sorts of things in, and very well what happened here is the defense was just not offered the opportunity to waive, which put defense counsel in a difficult position. Do you object to the judge in front of the jury as she's reading something? That's going to prejudice the jury and could harm your client.
Couldn't he have
Let her
just
go
asked to
forward.
approach? I mean, attorneys, when it's an issue that's detrimental to their client, they can say, Your Honor, may we approach?
I had the same thought, Your Honor, and I agree. But this is, again, a very odd situation to suddenly put the defense counsel in, and for the judge to proceed in this way without asking about waiver. That's just not the standard of practice in these cases.
But does the rule require the judge to ask?
It does not require the judge to ask, but then I would indicate the Lang case, where, again, it's differential to the defense. And that was the takeaway from Inree D.V. Lang from 2025. So there's not explicitly, the rule itself doesn't say you have to explicitly ask the defense this, but Lang would indicate you got to let the defense make the choice. You can't just presume the defense would or would not waive. It sounds like you're supposed to at least consult them to an extent. Now, I don't think there was anything malicious here. I think it was a general oversight or just a minor oversight. Those sorts of things happen. But I would also emphasize that in this particular case, there was serious error because the facts that actually came in at adjudication, supported by the witnesses and supported by the evidence, were very, very thin. Most cases, this wouldn't have made a difference to the outcome. There is still plenty of evidence to get us to preponderance for purposes of adjudication. It is a very low bar. But in this particular case, where the evidence was so thin, and there was no curative instruction, there was nothing else coming in to kind of fix that potential of the jury confusing what the judge is saying versus what was said by witnesses. And then on top of it, we have the issue of the no contest coming in when it shouldn't. We have the issue, with the being a hearsay issue, we have these just plethora of evidentiary issues in this very narrow situation with the specific facts of this case. We are asking the court to remand and allow a new trial on the issue of adjudication because of those issues. Most of the time, preponderance is such a low bar, it can be met very easily. This is the rare situation where there's a question if preponderance could have been met. And we couple that with these errors, we couple that with the 403 danger of unfair prejudice, we couple it with kind of this death by 1,000 cuts. There now becomes a question of the fairness of these proceedings. We stack on top of that historical problems of this being pushed one way or another, the potential for bias. We just are stacking all of these other potential issues in this particular case. It makes it difficult for an objective observer to walk away and say this was done fairly, ethically, in an unprejudiced way, and Mr. Pettiford got a fair shot at a fair jury trial. And that is why we are asking for a remand here. Again, we're not asking this court to say there is an adjudication. We are just asking for a second bite at the apple with a fair grounding, with the rules of evidence being on his side as he is entitled.
Okay. Thank you very much. Thanks for being here. Appreciate
Thank
it.
you all so much.
You bet. The matter is submitted. Turning now to item number 28, in Ray JG 375181. No one is endorsed for oral argument. Therefore, the matter is submitted. Item number 29, in re Vincent Miners, 376341. Again, no one's endorsed, therefore the matter is submitted. Final case, in re Zeller Minor, 376043. No one is endorsed, therefore the matter is submitted. That concludes the docket for today. Thank you all.